This podcast is a production of Widener Law Commonwealth in Harrisburg, Pennsylvania. For more information, visit commonwealthlaw.widener.edu/podcast.
Halloween is the scariest time of the year. For some people, the entire month of October is a festival dedicated to frights. On Halloween, we actively try to get scared by watching horror movies and going to haunted houses where ghosts, ghouls, vampires, and other monsters of all types jump out at us from behind dark corners. However, for many first-year law students, the scariest time of the year comes about a month after Halloween, when they take their first final exams. Final exams are exceedingly anxiety-inducing when you're a first-year student because such tests often make up between 75% and 100% of your grade. Adding to many first-year law students' insecurities is an incomplete understanding of the curve, a loose grasp of how to write an essay exam answer, and the general stresses that come with taking such an important test. For today's Halloween special, our guest is Professor Robin Meadows, who will join Mark and I in studio to answer an essay prompt inspired by the classic story of The Devil and Daniel Webster by Stephen Vincent Benet. Mark and I will also be talking about our experiences taking exams in the first semester. So, dear listener, it's time to face your fears and to overcome them. Happy Halloween. Joining us today is Professor Robin Meadows. How are you today, Professor?
Great, thanks, Jonathan.
Good. And now you've been teaching at Widener Law Commonwealth for how long?
28 years.
28 years.
Wow.
Wow.
Yeah, don't say it's longer than you've been alive, okay?
I mean, I had her last year personally.
Yeah.
I loved her.
Yeah,
She's
no.
great.
We both had her for first-year contracts. You teach first-year contracts.
Correct.
It was a pretty good class. It was hard for me because I came in here focused on criminal law, so I had to get myself into the mood for contracts and property.
Actually, it's almost the opposite. I got in here because I wanted contracts and stuff like that. So it really opened my eyes a little bit, to be honest.
And what other courses do you teach?
I teach upper level commercial law, which is related to contracts, and then I teach remedies.
Okay. And so that's why we asked you here today, because we have an essay prompt that is dealing with a contract. I've taken the story of The Devil and Daniel Webster and I've turned it into a practice essay prompt, the sort of thing that you would see on an exam, and we're going to run through just the steps of exam taking with Professor Meadows, and thank you so much for being here.
No problem.
All right. So I'm going to read off the prompt, and then we'll get into it. Mr. Stone was terribly unlucky. His farm failed, his family was sick, and his horse was about to die. Fed up with his terrible luck, Mr. Stone hyperbolically stated that he would sell his soul to the devil for good luck and 2 cents. The next day, Mr. Scratch arrived at Mr. Stone's house and offered him a deal stating that Mr. Stone would have 7 years of good luck in exchange for his soul. Mr. Stone orally agreed to Mr. Scratch's terms. Mr. Scratch then produced a contract memorializing their oral agreement, which Mr. Stone signed in blood. Mr. Scratch kept his promise and Mr. Stone prospered. Mr. Stone became rich and won a position in local politics. In the 6th year of the contract, Mr. Stone and Mr. Scratch negotiated a 3-year extension. Mr. Stone became insecure with his deal and broke the contract, citing his belief that it was invalid under the laws of New Hampshire. Mr. Scratch sued him for breach of contract. Assume that New Hampshire is governed by the UCC when applicable. Mr. Stone hired celebrated lawyer and Senator Daniel Webster to represent him. The jury was composed of nefarious characters from America's past, including Captain Blackbeard. The judge was John Hathorne, who had previously presided over the Salem witch trials. Will Mr. Scratch win his case? What sort of relief is he eligible to receive from the court? The first step in writing an essay is issue spotting.
Right, and I think also the first step is understanding that an essay question, although there's a question at the end, will he win his case? The point of it is actually to demonstrate to the professor your ability to spot issues, analyze those issues under the rule.
Yeah.
So the initial focus should be on issue spotting, because that's how we're going to develop our analysis.
Yeah, because all of the points are in the rules and the analysis, and if you don't get the issue, then you can't get the rest of those points.
Absolutely, you don't get anything. so what I think when I talk to students about issue spotting, what I recommend is that first read through. You should, every time an issue pops into your head, you should write a word or two to the side of those facts about what it is. So you can't see it, but as I was reading it, in the first paragraph, I'm seeing, is Mr. Stone hyperbolically stating he'd sell his soul to the devil for good luck and 2 cents? Is that an offer? I wrote offer next to it. Oh, well, wait, then Mr. Scratch comes and makes an offer. Oh, is that an offer? And then, he orally agreed. Is that an acceptance? So I'm writing next to it every time something is triggered. And ultimately, I might go, that's not really an issue. Yeah. But it's better to put it down and spot it. And some students struggle with that. And the best way, if you struggle, is actually put that into your study materials, into your outline. I'm going to spot this issue by blank. Right?
So we should definitely be looking over this more than once at least.
Yeah, I think because the advantage of writing all of these possible issues down is then when you start thinking about how you're going to write it, when you're talking about offer, you know where to go back to the facts that are relevant, right?
Yes.
So that you don't just sit there reading it once, twice, 3 times. The first time is you're doing some issue spotting. Maybe if you feel like you didn't get enough the first time, you might go through again, see if you spot some more issues. But then you should start getting into the active, okay, now I got to start writing. Now I got to start organizing. Let's see what I do.
Yeah.
And so that's how, but don't just sit there reading it 3 or 4 times because you are getting nowhere.
Yeah. And you also have to look out for red herrings too, because sometimes professors will put red herrings into their prompts, not for any mean reason or anything like that, but they do it because... She's smirking. But they do it because in real life, in practice, and correct me if I'm wrong here, a client will come in and they'll tell you everything. They'll tell you irrelevant things like, I'm having a divorce and also my dog's sick.
Right, absolutely. And you have to both spot what is an issue and what is not an issue. So in yours, for example, assume that New Hampshire is governed by the UCC. Yeah. Well, that's a red herring because the UCC doesn't apply to this transaction.
UCC only applies to the sale of goods.
Right.
Exactly.
Yes. And souls and lucks are not goods.
Yes.
Right? So, because it's got to be tangible. And so that, and you do see that, and partly that could be there to see, do you know that the UCC doesn't apply? That's testing whether you knew that. Yeah. So most things, you're absolutely right, most things that are in there are there for a reason. Yeah. Not to confuse, but to sort of see what can you tell what's important, what's not important.
Yeah. It's to test the true aptitude of the student.
Yes. Yeah. Would you give points if after the student went through all the issues, they wrote a quick blurb about the non-issues? Just saying, the UCC doesn't apply here. Would you give them points for that?
Well, because it was stated here, I probably would, because then I would be wanting you to tell me the UCC does not apply because it only applies to sale of goods, and this is not a sale of goods. If it wasn't there, then I would just say jump into the common law. Okay. But since this is there, it's at least worth, sort of getting rid of it and saying, well, no, that's not the governing law.
Yes.
And I would do it right at the beginning. Because you got to use the right law.
Yes.
Right? So right at the beginning, you'd say, the UCC does not apply.
Yes.
Because it's not a sale of goods.
Speaking of the beginning, how would the formula, I guess, for writing an essay work exactly?
Well, you're talking about organization?
Yeah.
Yeah. So...
Okay. Well, you have organization for an answer both at the macro, the big level, right? The overall level, and... the micro, which is every single little issue. Contracts tends to lend itself to one particular organization scheme. That is, you have to talk about offer before you can talk about acceptance, before you can talk about revocation of the offer, etc. So if a class has, it's sort of linear, if you think about it. So classes that are linear, that sort of you have to ask this question, then this question, then this question, then you want to organize it that way. Sometimes, so like for example, if it was a torts question and you had a whole bunch of different torts in it, well, it doesn't matter which torts you talk about, but don't jump back and forth. So, if it's assault and battery and maybe false imprisonment, it doesn't matter which one you talk about first, but talk completely about assault, then completely about battery, then completely about false imprisonment, right? So and I really recommend thinking about that in every single class before you sit down for a final. How am I going to organize this?
Because organization, it really is key when it comes to writing down. You have to come up with something, a little bit of something, an outline almost. Before you can really...
Right.
Yeah, and I remember you telling me this, Professor Meadows, in one of our exam conferences last year, was don't make me go looking for your point. Just tell me what it is that you're trying to argue. Like, don't make me go searching for it because I might not find it, and then you lose the points.
Right, and if you have a good organization and then you organize each paragraph, I say, each issue should get its own paragraph, right? And that first sentence in that paragraph should be either, depending on if you IREC or CREC, and we'll talk about that in a second, either the issue or the conclusion, but whatever, that first question, because that's going to tell me where it's at. And I think that's absolutely, both on the big scale and on the small scale, that organization is key. And the reason I say you should think about it before you go in, I just gave a practice essay in my contracts class.
What a coincidence.
Coincidentally. And a lot of the students said, oh my gosh, 30 minutes went by way faster than I thought it would. I bet both of you have had that experience.
Yes.
Oh, when I started out. Mm-hmm.
Yes.
Right. Like you think, when you think about the final exam, a lot of times they're 3 hours, and you're like, oh, that's lots of time. No, it goes like that.
Yeah.
Well, if you have to think about how you're going to organize it in the exam, you're wasting time.
Yeah.
Right? So this way you think, okay, well, when I have contracts, I talk offer, I talk acceptance, and I do consideration. You have a plan, and having that plan is key.
Yes. So as far as issue spotting goes, I know that we discussed this yesterday over email. There were several issues, and I wrote the prompt and I missed a couple.
Whoa.
Sometimes you need a fresh set of eyes, that's all.
Yes, exactly. So, but for the interest of time here, we should probably only go over pick out one issue and run through the analysis of that and not through all of the issues, because then we could be here all day.
Right. Yes, exactly.
So,
you wrote one that had lots of issues.
Yeah.
And I think probably the best one to talk about would be consideration.
Yes.
But I'll just sort of, in a big organization, you would sort of start with a contract requires mutual assent, that is agreement, and consideration.
Yes.
And here, the first paragraph's your agreement, and it's pretty clear. It wouldn't take a lot of time to talk about that, right? You want to talk about offer, accept, but not going to take a lot of time. The real question here, the big issue, is consideration.
Yes.
And consideration is the requirement that contracts be a bargain for exchange, that it's a bargain, that I exchange something to you and you exchange something back to me. That's sort of the layman's version of consideration.
Yes.
There's all those little small rules about nominal and all that, but we're not gonna.
I'm gonna go there. But so if consideration's an issue, going back to you should have a structure.
Yeah.
So like in my class, hopefully you both remember, when we talked about consideration, every day on the board we had 3 requirements. You must have legal detriment. The detriment must induce the promise. The promise must induce the detriment.
Yes.
Right.
Right.
If it's on the board every day, that's how you want to do it. That's like one of the hints. If a professor says this is the organization you should use that organization.
Yes.
Right?
Yes.
So I think that's a big, really pay attention to that.
Yeah.
Because we all ultimately want the same thing. That rule analysis that you guys were talking about, where the points lie.
Yeah.
But organization, a lot of times you get a lot of, hints if you pay attention in class on how to organize it. So for consideration, here the issue is, because what they exchanged was good luck for Saul.
Yeah.
And maybe 2 cents, maybe nominal, but we'll leave that for another podcast. But good luck for a soul is that legal consideration.
Yes.
And that's the one that's worth talking about.
Yes.
Right? And so you start with your structure, and then you want to make sure you always define legal terms.
Yes.
So legal detriment is a legal term.
Yes.
explain what it means, right? That's your next step, no matter what. It's a lot like you'd explain what assault was, or you'd explain when I said a contract's agreement or assent and consideration. We're explaining what it is, right?
Now I want to see if I can remember this real fast. And if we don't, we can cut this out. But detriment is basically because you are giving up something of value that is a detriment to yourself because you no longer have that thing of value because you're giving that in expectance of an exchange for something else of value.
That's one way.
Yeah.
I mean, consideration, it's doing or promising to do something or give something up that you are not legally obligated to do. So you're giving. The other one is to refrain from doing something that you are legally entitled to do. Okay, so it's either giving up something you have a right to or doing something you are not obligated to do. And that's the value that we look for.
So structure-wise, we would be in the R section of an essay right now. We're, defining all these different terms and talking about considerations.
Yes. Absolutely. And you'd also want to talk, so after you define it and you explain it, because that's the definition, and you want to sort of you'd use in an exam, you'd use your legal terms, right? But then you have to go a little deeper. And a lot of times that's the difference between an A and a B or a C is going that deeper.
Yeah.
Because the deeper is that not everything that you do that you're not legally obligated to do or give that you're not legally obligated to give is considered legally consideration. For example, love and affection is not consideration. Everybody knows that, right?
Yes.
And so the question here, the big question here is good luck, is giving somebody good luck consideration?
Right.
Is it closer to something like love and affection? Does it have a monetary value?
Yes.
Could we value it? Right?
Yeah.
Could we measure it?
So that's a good point because the good luck leads to, fuller crops, which leads to money, leads to a position in local politics. So that's a job. So would that stuff
But how do you
apply?
prove that? It's also got to always think about how you prove it. Could it? I mean, how would you prove that? Oh wait, we don't want to call him the devil, Mr. Scratch. How would you prove that Mr. Scratch was the one who gave the good luck? If you give, if you give me $500 if you mow my lawn, right? Or you give me $500 if I mow your lawn, rather.
Yes.
I can measure you gave me $500, and you can tell if I mowed your lawn or not.
Yeah.
How would you tell? That's the debate.
Yes.
And that a lot of times in your analysis, it's just a debate, right? How would we ever know if Scratch gave the good luck, or did his luck just change? I assume everybody's had times where they feel like they got bad luck, and then they got good luck, right?
Yeah.
Yes.
And how would you ever show he gave it? So that's one consideration. Is luck really just like love and affection or conjuring or something like that?
Yes.
You have that issue. So I think that's what you'd want to see after you state the rule and you explain the rule. That's where you get into it.
Okay.
And here it would be debatable, and that's fine. And then both parties have to give it, so then you get to move on to the soul, right?
Right.
That I think is probably a little easier.
Yeah.
We can't sell people, so I suspect you can't sell your soul.
Exactly. It's all about as the professor said earlier, it's all about either giving away something that you're not legally obligated to give away, or refraining yourself from doing something that you're not legally you're allowed to legally do.
Yes.
And in this case, we don't really have either option. We don't have a material aspect to it where you can tangibly have something to consider a detriment, and at the same time, it's not something that he's taking away from himself or refraining himself from doing. You really don't have an idea either way, and it's very arguable, and that would go into your A section of the analysis.
Absolutely, that's it. And that's when you get that's when you do a really good analysis, is you're like, I'm seeing both sides of it here, and I'm struggling, and that's fine. And sometimes I've started to tell students this, keep me guessing to the end. Okay. Don't tell me the conclusion until the end of the question.
Oh, interesting.
Because if it will force you into making that debate, because if you read this and you go into it thinking it's a contract, all of your analysis will be justifying your conclusion. If you keep me guessing to the end, then you're going to be doing that debate you were just doing, Mark, on the paper, and that's where you get all your points. Mm-hmm. So I say keep me guessing to the end.
Yeah.
Right?
And I think that's a common sort of trap that first-year students and even I would think students of all years fall into is we convince ourselves, I know the answer, so now I've got to prove this.
We almost feel like we have to have an answer before
exactly.
we even put something on paper.
Right. Yeah. So it's like you see, so there's... So like when I was writing up the practice answer for this, I like hyper focused on breach, and so I went into my old contracts outline. I got all the elements for breach, and I just went through all of those, and I was like, okay, I'm done. But I missed, some of these other ones.
The fact that it's probably not an enforceable contract.
Yes,
right.
exactly.
And you can't have breach, and it that relates to, and sometimes the questions at the end are good prompts to get you thinking.
Yes.
Because you asked, will he win his case? What sort of relief? Well, if you think about it, even if it was a contract, there is no relief that can be given.
Yes.
Because there's only two types of relief, which is money and specific performance, where you compel the party to actually perform the contract.
Yes.
Well, you can't do specific performance in a personal contract like this. You couldn't compel somebody to give their soul up, right?
Yeah.
And how would you monetize good luck or a soul?
Yeah.
And so that relates to the consideration, right?
Right.
And so those questions can help you find issues when you start thinking about it, and help you relate the issues together, which is what makes a great answer.
It's almost like hearing it for the first time is an eye-opening experience, even after you finish your first year.
Yes.
I suspect after you finish your first year, you're more, I don't want to say more open, but you're more understanding of it because you've been through the process. Because I guarantee I've said these things to people. And they don't necessarily do them. And then after they've lived through the process, like, now and then you get more knowledge after 2 semesters, and you're like, right, that makes sense. So it's context, it's evolution. That's why professors, every semester we expect more of our students, right?
Yes.
So people are going to make a lot of mistakes in the first semester, right? Mm-hmm. And we expect that. We expect fewer mistakes in the second semester. We expect fewer mistakes in the second year. And we expect even fewer mistakes in the third year. Because you're students, you're learning, you're improving. That's the point.
Yes. And that really is because, none of us perfect, but we keep working every day in order to become competent and productive attorneys in the future.
And that's why it's called the practice of law.
Yeah.
You got to keep practicing even when you're a lawyer.
All right. Now, the last thing that I would like to ask you about, and I think this is another common thing that people get hyper-focused on, is the conclusion. How much is a conclusion worth in an essay exam?
My essay exam's very little. Maybe a point, and that might be a point out of 30, right?
Yeah.
Because if you've done a really good analysis, which requires you to have first explained the law very clearly, and spotted the issues. If you've done that, then I'm happy. And I've actually had people who get the highest grade in the class who literally the conclusion was wrong at every single question. Because they did a perfect analysis, but they didn't have the experience to go, wait, that doesn't work. Right?
Right.
But if you do that great analysis, you're getting 99% of the points. That's okay.
Yeah. Yeah. So that's always show your work.
Right. Absolutely. Just like in math, always show your work.
So, since we're on this topic of showing your work and, organizing it in a way that allocates you the most points possible, how long do you think we should take before we actually end up writing the essay on just, outlining for it?
Yeah.
I think it really depends. Some people struggle with writing unless they really do an exact outline.
Yeah.
And for them, I think they don't spend all of your time. I've had people who spend out of a 30-minute question, they spend 20 minutes outlining. That is not enough. You're talking about an outline's got to be very skeletal. You read it, let's say it's 30 minutes. By minute 10 at the latest, you should be typing or writing an answer, right? You should absolutely be doing that. Some people, and for example, when I took it, I didn't do an outline, but I used my handwritten notes alongside my essay as my outline.
Oh, okay.
That was my outline, right? Because every time I saw an issue, I wrote it down, and then I could look at those and say, okay, I need to talk about this one first, this one second, next one third, and it just, for me, sped it up.
Yes.
But some people like to say, no, I really need to put it down, make it skeletal, don't spend so much time. And unless you are afraid you might forget a rule, I wouldn't put the rules in your outline. I'd put the rules in your, like you said, offer, and maybe there's a sub-issue of preliminary negotiations.
Yes.
So you put maybe offer, preliminary negotiations, acceptance, promise or performance.
Yeah.
Like little triggers. But if you spend all your time writing up your rules, you're going to have no time to write.
Right.
Yes.
Right? And so I think and I suspect people evolve, you try it. That's why I always say practice.
Yes.
Before you get into that exam, right? You have never mastered anything in your life without practice.
Yes.
Right? You practice learning how to drive. If you play a sport, you practice the sport. If you play an instrument, you practice an instrument. This is a skill. You can learn it. You need practice.
Luckily, we have a wide variety of essay prompts on our library website. And,
Yes.
there's also a lot of different study materials that we can use.
Absolutely. A lot of them provided free.
Yeah, and there are also just practice books in the library, too, that you can just go to. Like, I know because I work in the library here, and we have an entire shelf that's all just practice exam books and books explaining things about different topics.
What can we take away from this? I guess we can take away that you do need an organizational structure. Before you can get into it, you have to really look at your facts. You have to really evaluate them. Look out for red herrings. You have to look out for specific issues that you can actually put into your essay. From there, you use either go into a little skeletal outline or, do the issue spotting as Professor Meadows had pointed out to us. And then from there, you got to go directly into your IRAC and, work it out.
Yeah.
And IRAC every issue. That's so important,
Yes.
right? Every issue you're doing that. But absolutely, I think that's the takeaway.
Yeah, no, I think so too. Organization is key when you're writing the exams, and just knowing your content before you go in there. Because, like you said, you can't take 20 minutes before you start writing, and if you take 5 minutes just trying to remember what the rule is, then you're going to have a bad time.
All of this presupposes you know the law really, really well,
Yeah.
because you can't spot issues unless you know what the law is. You can't tailor the rule unless you know what the law is, and those two are required for analysis.
Yeah, so, and I think, there's more of a connection between your in-class experience and your reading and just everything that you're doing every day. Like it's hard, like you can't take a day off of your reading, because then you fall behind, and then maybe you lose, that one thing that you need on the test.
Exactly. And then all of that builds up to your exam experience.
Yes. Well, Professor Meadows, thank you so much for coming in and working with us today. Thank you for doing the prep work that of looking over this exam for us. And we know that you have a lot going on. We just thank you for taking this time to be with us.
Honestly,
My
this has
pleasure.
been very eye-opening. And even now as a 2L, I'm still going to be using these tips that you just gave us.
honestly too, it's pretty great, because it forced me to refresh my memory from contracts, because it's been about 5 months since the end of the second semester, the end of our first year.
Yeah.
And so, it's I haven't thought about contracts since then, and it forced me to bring up that knowledge that was just buried deep in my brain.
That's important.
because when you get to the bar, you have to remember 3 years worth of things.
Exactly.
So, there we go.
So thank you for coming on.
Yes.
My pleasure.
It's now time for 5 minutes of unsolicited advice, where we go around the table and give our views and our experiences on topics that affect us all. Today's topic, study groups.
First semester, just like I did in undergrad, I was kind of the lone wolf. I like to be by myself and just kind of sit there and take 8, 9, 10 hours at a time, just really focusing in. But second semester came around, I didn't do as hard as I wanted to do. I kind of started reaching out to other people, comparing notes and their notes with my notes. Say I might have missed something that I did not have in my notes, which I think was a huge beneficial help. And then in the end of the night, toward 11, 12 o'clock at night, we all came together. We ran through a couple problems, multiple choice questions, and we just talked aloud amongst us, and it kind of gave you different perspectives of how to think about each and every aspect of whatever question you're facing at that time. So
I remember being there for a couple of those, actually.
Yeah, they were good times.
They were good times. Basically, for me, when it comes to study groups, my first semester, I was the same way as Connor. I basically did a lone wolf scenario type thing, and I had maybe 1 or 2 people that I would outreach to, tops, and that didn't really help me a lot when it came to my grades. And then second semester, I realized that a lot of this is, sure, we might be competing against each other, but if we can help each other on the way up, we'll both be doing better than the person who's alone. So, in my opinion, I personally loved it when I started working with my study groups and everything like that. And it just helped me to, I guess, organize my thoughts and learn a different perspective. It really helped to open my eyes a lot more to the information that was given to me than just by looking at it over myself, you know?
See, I have a different experience with that because my study group the first year, we were really good friends, so we would just end up talking and just hanging out, and we wouldn't get any work done together. So we all agreed to not study together the second semester, and we all did better.
Oh, that's interesting.
Yeah.
yeah.
Mark, I'm so happy that Professor Meadows came in and helped us refresh our memories and our experiences from last year of how to write an essay exam. Do you feel like you've learned something today?
Well, honestly, this has definitely been quite the refresher for me. You could say that I was looking at this through refreshed eyes, but it was very interesting to just get to talk to her again about essay, specifically because, we're almost entering back into that stage where we're going to have to be focusing on essays once again for a while, So it's really good to be able to get that refresher.
Yeah.
But, I mean, let's kind of...
And she's such a cool professor, too.
Oh, yeah. No,
Like,
she's really awesome.
She's really easy to talk to. She's very approachable, and she's always making time for our students. Like, she's my advisor, and, I think I was in her office, 3-4 times a month last year.
A lot of professors are. A lot of students their first year are hesitant to, go and talk to the professors because they're afraid that, they might look weird doing so. But honestly, the professors are there to help you. And at the end of the day, you're not going to get that help if you don't go to them. So you might as well break the ice with them. And, it's just a good way to start it off. It's definitely in the beginning of the semester, too.
Yeah, and this was a good example of what final exam conference is like in real life, where you meet with your professor, you run through a practice exam, and they tell you what you've done right and what you've done not so right. And I think that it's time that we do a recap of what we've learned or maybe relearned today.
I would love to do a recap.
Okay, so IRAC, as we discussed, is an acronym for Issue, Rule, Application, Conclusion, which is the structure of an essay exam. Mark, tell us about the issues.
Well,
and issue spotting.
Issue spotting is interesting. It actually comes before you even start with the IRAC, because what you gotta do is you have to look at the facts. As Professor Meadows said, read it over once or twice, really look through and spot the red herrings, and then spot the quality issues that you can really work with. And from there, you add anything that, you wouldn't put into your rule and application, but you want to make mention of for a point here or there. That's where you add it into the introduction, just to get those points allocated.
Yeah.
Also, the I is, where you put your issue. Meadows made a really good point, I think, where you don't want to rush to a conclusion immediately.
Yes.
You want to have your issue at the beginning and then work your way towards a conclusion, because that gives you more freedom both mentally and when writing to debate both sides and really allocate those points.
Yeah, if you leave the conclusion open, then that frees you up to have that discussion and get more points.
Right.
And as we talked about with Professor Meadows, a lot of those points are in the rule. Let's run down the rule again.
The rule is basically you writing down almost the monotone rule for exactly what the issue you spotted is. So if you're going to work on a debate, you're going to have to explain the rule first. You're going to have to lay out what the rule is and work from there. So what you do is you write out your rule. You make it very easy for them to understand, very clear, but detailed. Don't try and rush it. A lot of people you see try and rush it so they can get into your application. You should really write out your rule and make sure to add in, when acceptable, some flavor. So not just writing down the straight monotone rule, but adding in the exceptions could potentially be if the exceptions do apply in this fact pattern.
Also, with the rule is the part that you probably need to study the most, because sometimes the rules are plainly stated. Like if you're dealing with the Uniform Contracts Code, the UCC, it tells you exactly what the rule is. But if you're dealing with the common law, then you need to go back through those cases and you need to synthesize the rules from each of those cases in order to come up with a general rule that you can apply on the exam. And that's what you're talking about with the flavor too, is explaining that rule and giving out all the exceptions, because no rule is absolute.
Absolutely correct.
It's good wordplay.
Yeah. But after that, obviously, you go on to your application section, the A. And how would you write up an application section, John?
I mean, the application is basically, once you've stated the rule and defined the rule, that's when you take the facts given to you in the essay prompt and you apply those facts to the rule in order to see, how is this going to come out. Because in the prompt that we had previously, we have a rule about consideration. And is there sufficient consideration given between Mr. Scratch and Mr. Stone? And we said, well, likely not, because, what is a soul worth? What is good luck worth? How can you prove good luck? And you have to apply all of this to that rule.
And remember, this is something where you have to really consider both sides of the argument.
Yeah.
You can't focus yourself on one side if you think that's going to be the correct side. This is the section where you really break down both sides and try and argue the rationale, and from there naturally try to come to a conclusion.
You have to take both sides into account in order to fully analyze the question. Otherwise, you're just left with a bunch of holes in your answer that's going to lose you points.
Right. The rules section and the application section are by far the most vital points of your exam.
Yeah. And last and also least is the conclusion, which is not worth that many points, and which also, if you focus on the conclusion, it can lead you astray, because then you're just trying to vindicate your answer that you came up with.
Now, we're not saying don't write a conclusion. That's not, I guess, what to take away from this. What we're trying to say is that the conclusion is something that you need to have in play, but it shouldn't be the source of your answer.
Yeah. Your conclusion is one sentence at the end after you've evaluated both sides of the issue.
Absolutely right.
A good exam comes from paying attention in class, being engaged with your professor, going to your tutors and your ASS if you need to, using other study resources.
Like the ones that are on the library website, which honestly, I know this sounds, commercial, but it really is useful. I use them a lot in my first year.
Yeah,
they help me.
They're so helpful. And we actually have a link to those resources in the description. Stephanie Inger, our engineer, is putting those in into the description.
That should be helpful.
Yes, I think it will be helpful to many first-year students as they prepare for finals. one of the problems that I had in my first year was I was too proud to go see my tutor, and I was too proud to ask for help. That was only to my detriment, because I go see my ASF now all the time. I go ask for help all the time, because if you don't understand what the rule is, then you lose all of your points.
They say pride is the downfall of man, and I agree with that sentiment a lot, especially when you're going to law school.
Yes.
You have to be able to keep your pride back, and you have to be able to go and, talk with other people if you need the help. It's not going to get any better unless you go and you bravely take the first step towards reforming yourself.
Yeah, and that's the thing about law school. It's so different than anything else that a first-year student has done before. The studying is different. You can't pull an all-nighter and expect to do well.
Oh God, no! Do not go and try and study everything and outline everything the night before your final exam, because that is not just shooting yourself in the foot. That's shooting yourself in the torso.
Yeah, and also, just being fully aware of everything that you need to get done and being organized. So for all of us here at Things I Wish I Knew, thank you for listening, and happy Halloween.
Widener University Commonwealth Law School is the Pennsylvania capital's only law school, with 3 specialized centers of legal scholarship through its Law and Government Institute, Environmental Law and Sustainability Center, and Business Advising Program. Widener Law Commonwealth offers an exceptional learning experience that is personal, practical, and professional. Visit commonwealthlaw.widener.edu for more information.